Mr. Speaker, I hear the words of the Minister of Justice seeking support for this bill. And the truth is that this idea of reposing the responsibilities that were vested in the office of the political ombudsman under the Principal Act, reposing them in the Electoral Commission in some way, has been promoted for some time. And indeed, I believe members on this side had at times indicated that that was a good idea. But with the passage of time, I must say that, speaking for myself, I have grave misgivings about it. First of all, I'm going to speak about the process by which this bill is coming here. We have not been sent a copy of this bill. We're seeing it for the first time when it's tabled this afternoon. I don't know whether there are errors in it. It's repealing and amending numerous provisions in the Principal Act. We have seen where bills that have been pushed through here before have errors in them and are going to have to be fixed by subsequent legislation. We're seeing it with the firearms legislation, and indeed we're seeing it with the other amending bill that was tabled by the Minister with responsibility for transport today, the Road Traffic Reprieve and Nullification of Prescribed Notices Amendment Act 2024, which is seeking to correct things in the Principal Act passed a year ago, the Road Traffic Reprieve and Nullification Prescribed Notices Act 2023. So something like this should not be tabled and passed on the same day, because we should need to have a chance to look at it more carefully. Secondly, this impacts the Electoral Commission of Jamaica, and matters to do with electoral law have been approached in a bipartisan way for the last 30 or so years in this country, 40 years. For good reason, because we come from a history of intense partisanship in our politics, which has at times spilled into the realm of violence. And we have tried our best as a nation to evolve away from that. And the Electoral Advisory Committee, which has, through various iterations, become the Electoral Commission of Jamaica, which subsumes the Electoral Office of Jamaica, has built an enviable reputation for its expertise and its independence. And the reason why that has happened is because of the approach, the convention, so to speak, by which both political parties have operated in relation to that institution to try and ensure that as much as possible things proceed in a bipartisan way. Therefore, if you are going to proceed with legislation to integrate the political ombudsman's office or functions through legislation into the ECJ, surely there ought to have been some bipartisan discussion on the specific provisions that you are bringing to Parliament. There has been none. The last thing I heard about this before a week or so ago, when our representatives on the ECJ told me what was being proposed, what I'd heard before was that what was being proposed was to save costs by establishing within the Electoral Office of Jamaica a position that would be supported administratively by the existing administrative arrangements of the Electoral Office, so there would not have to be a duplication of administrative staff, and that office would play the role of the political ombudsman. Apparently that idea lost favor and morphed into the commissioners themselves becoming the political ombudsman. And as I said before, I think the process that is being followed is wrong. I do not think we should be seeking to pass this bill today. I think we should have proper discussions about it and a period of time to reflect on whether or not it's going down the right path. From a substantive point of view, my misgivings are that the Electoral Commission has achieved a level of stature in the society, even internationally, because it is perceived as being independent and out of the fray. And it takes its decisions not by favoring any political party, but in the interest of fairness and efficiency of the electoral system. And that is a very valuable reputation to have developed. That stature should not be diluted, or we shouldn't play games with it. By investing these responsibilities in the ECJ, they are now going to have to adjudicate like a quasi-judicial body on matters that will be intensely in dispute between partisans in the political process. And that is now changing the character of the ECJ by giving them functions which are completely inconsistent with the detached, independent, and objective aura that they have enjoyed for so long, where they have the nominated representatives and the selected representatives. The two political parties have, I think, 2 representatives on the commission each, and then there are the independent persons or persons of repute, and indeed the way they are appointed by the Governor-General, there is a consultation process between the Prime Minister and the Leader of the Opposition, so that we typically would enjoy, whoever's there as an independent body are those the nominated representatives. The nominated representatives typically enjoy the trust and confidence of both political parties because of the way in which that convention has worked. So I think this is going down a dangerous and wrong path. I do not think that the ECJ Commissioners should take on this function of being an adjudicatory body on political disputes in the heat of election campaigns. That is completely inconsistent with the way in which they have operated in the past. And I don't think we should be going down this route. That's my own view. Secondly, what I've heard the minister say is that they are to function as a political ombudsman as an indivisible body. Now, I believe there are 9 ECJ commissioners. 9. This is like the U.S. Supreme Court, which has 9 justices on it when it sits. Does that mean that when a dispute has to be adjudicated, all 9 have to be present? There are no regulations governing the procedure for the adjudication of these matters. This piece of legislation doesn't have anything in it about the adjudication procedure that they will be obliged to follow to comply with the rules of natural justice, but also to allow them to operate with some efficiency, given that there are 9 of them. If one is absent, does that mean a hearing can't be held? Or 2? There are no procedures to govern how they operate, and it should not come here without those procedures being part of it, because those procedures will themselves be contentious, or could be, and ought to be something that there is bipartisan support for. This bill here says nothing about how this indivisible body of 9 commissioners will operate in practice and in law when a matter comes before them where 2 or more persons in the political fray have had a dispute of one sort or another in the heat of the electoral process. So I don't think this is ready. I don't think it's a good idea, and I cannot support it. The process is wrong. We were not involved in the development of this bill. We never had a chance to look at it. We do not know if it has errors or not. And in principle, I think it's going down a dangerous route. And I acknowledge, Minister, that in the past we may have supported this idea. But with the passage of time and the discussions that we've had, especially recently internally at our executive and so on, we have a grave concerns that this is not the right approach to be taking. And I don't like the idea of us having a difference of view in this forum on a matter like this, because that's not how we've operated in relation to the ECJ in the past. So it really pains me to having to be saying these things. But I have no alternative, because I hold these views strongly, and I think I'm right in principle, and I have to articulate my position on it. So, Mr. Speaker, I cannot support this legislation, either because from the point of view of the process by which it got here, which is deeply flawed, and because substantively I think it's a wrong approach. It's a dangerous approach, and it will not inure to the benefit of Jamaica's electoral system. I thank you, Mr. Speaker.